කතානායකරයා විසින් කරනු ලබන නිවේදනාංක 1 Honorable members, I wish to deliver my ruling on the matter of privilege raised by Honorable Dayasri Jayasekara, Member of Parliament, on 7th of October 2025, as the issue raised concerned the privilege of Parliament as a whole in terms of Standing Order 29(1) of Parliament. The Honourable Member alleged that the Leader of the House had misled the Constitutional Council during the process of nominating a candidate to the post of Director General of Commission to the Investigation Allegations of Bribery or Corruption on the 24th of October 2024, thereby committing a breach of privilege under Section 4 of Schedule A to the Parliament Powers and Privileges Act. The member therefore requested that the matter to be referred to the Committee on Parliamentary Privileges for investigation. Having carefully considered the matter, I now proceed to give my ruling.
Most popular creative campaign.
CBL Manchi Savory category.
Nature of the Constitutional Council. The first issue that requires determination is whether the Constitutional Council is a committee of Parliament, so as to attract the application of the provisions of the Parliament Powers and Privileges Act. Under Article 41A of the Constitution, the Constitutional Council is established as a distinct and independent constitutional body. It consists of the Prime Minister, the Speaker, the Leader of the Opposition, one of the Member of Parliament nominated by the President, and the several other members who are either ex officio or civil society or appointed by the President on the nomination of the Prime Minister and the Leader of the Opposition. It is thus not a parliamentary committee established under the Standing Order of Parliament. The Constitutional Council functions under the Constitution itself and not under the authority of Parliament or its standing orders. Therefore, any proceedings or decision of the Constitutional Council cannot be regarded as proceedings of Parliament or of a committee of a Parliament within the meaning of the Parliament Powers and Privileges Act. Applicability of Section 4 of Schedule A to the Parliament Powers and Privileges Act. Section 4 of Schedule A to the Parliament Powers and Privileges Act provides for offences in relation to the misleading of Parliament or a committee of Parliament. Since I have already stated the Constitutional Council is not a committee of Parliament, the said provision does not apply to the acts or deliberation of the Constitutional Council. Accordingly, even if it is alleged that the Member of Parliament made an incorrect or misleading statement before the Constitutional Council, such conduct would not fall within the ambit of breach of parliamentary privilege as contemplated by Section 4 of Schedule A of said Act. Finality of decision of the Constitutional Council. Furthermore, Article 41J of the Constitution explicitly provide that the decision of the Constitutional Council are final and conclusive and shall not be called in question in any court of or tribunal except by the way of an application made to the Supreme Court under Article 126 of the Constitution alleging a violation of fundamental rights. I am informed that in relation to the said appointment, 3 fundamental rights applications were indeed filed before the Supreme Court, naming the members of the Constitutional Council as respondents. It is also noted that those applications have subsequently been withdrawn by the petitioners without proceeding further. This confirms that the proper constitutional mechanism to challenge the decision of the Constitutional Council lies before the Supreme Court, not within the form of Parliament. Ruling in view of foregoing, I am of considered opinion that the Constitutional Council is not a committee of Parliament but distinct body established under the Article 41A of Constitution. The provision of Section 4 of Schedule A to the Parliament Powers and Privileges Extra, therefore inapplicable to its proceedings. The allegations made by the Honourable Member does not disclose any matters of breach of parliamentary privileges. Any grievances or challenges concerning the decisions of Constitutional Council must be pursued only through the constitutional remedy available under Article 121 of Constitution. Accordingly, I rule that no questions of privilege arise in this matter, and hence the issues raised by Honourable Dayasri Jayasekara MP will not refer to the Committee on Ethics and Privileges.